find their seats. Thank you all. So we're going to begin the second panel of the morning. And if people could find their seats so that we could get going, appreciate it. The subject matter of this panel is statehood and statelessness. And again, I'm going to ask everyone to please find a seat and so that we can get going. And I'm happy to call upon our first speaker, who is Jenny Grota-Stoutenberg, who is with the University of Berkeley, California School of Law.
Good morning. We know that climate change and sea level rise threaten the sovereign existence of low-lying island states like the Marshall Islands. What I will address today is the question when exactly these sovereign states would cease to exist. In customary international law, there are 4 objective criteria for statehood. A state must possess a defined territory, a permanent population, a government, and a certain measure of independence. If an island state became completely flooded and the entire population had to relocate to other countries, these objective criteria would be lost. But just like sea level rise, inundation and emigration will most likely be a gradual process. I will therefore ask what the thresholds are at which a state disappears. And the criteria I just named are factual criteria, but in international law, somebody always has to draw the consequences from certain facts for them to have legal meaning. So I will also briefly talk about who has the competence to determine whether a small island state has become extinguished. In the third section of my presentation, I will take a step back and question whether small island states would really cease to exist as legal subjects, even if they lost the objective statehood criteria. As we will see, other states have a moral and perhaps even a legal duty to continue recognizing island states that have lost their effective statehood. And I will conclude by summarizing the main policy recommendations that follow from the legal analysis. So first we come to the thresholds of effective statehood. The first statehood requirement is that of a defined territory. As we heard this morning, a small island state would most likely become uninhabitable long before it became completely submerged. So the question is, does uninhabitable land qualify as state territory? And a functional or teleological interpretation of the statehood definition suggests that it would not qualify as territory, because the territory requirement wasn't introduced in the statehood definition as an end in itself. It's rather a means to an end. It is the physical basis that ensures that people can live together as organized communities. So, according to a functional interpretation, only land that is inhabited qualifies as state territory. It's of course different when an existing state owns a small, remote, uninhabited island somewhere, because then this island shares the legal status of the whole. But where an uninhabitable piece of land is the only land left, that's not enough to qualify as state territory. So the important conclusion here is that if island states want to maintain a state territory, they have to prevent at least a certain part of the island from becoming uninhabitable. And a way to do this would be to elevate or reinforce an existing island, or even build a completely new island like the Maldives have done with the island of Hulhul Malé. And elevated or reinforced existing islands maintain their status as natural islands, because the island state would just try to preserve land and maritime zones that are already there. A newly built island, on the other hand, would qualify as an artificial island. But while they might have a different status under the law of the sea, in both cases, the island would still constitute territory. Because if we look at the genesis of the artificial islands regime from 1930 on, it becomes clear that artificial islands were always assimilated to natural islands when it comes to their quality as territory, although their capacity to generate maritime zones was abrogated in 1958. So even an artificial island would therefore still qualify as defined state territory. The situation would be more complicated if the island state tried to replace its territory with an artificial installation. President Tong of Kiribati, for example, said last year that he was thinking about buying so-called floating islands from Japan. And such floating islands would qualify as artificial installations rather than artificial islands, because they would not be heaped on the seafloor, but only be connected to the seafloor through stilts or moorings or the like. And historically, such artificial installations were never assimilated to natural islands, and they do not qualify as territory. But on the other hand, it is very likely that if a small island state claimed that a floating island was its new territory, other states would agree to this on grounds of fairness, as long as the island state did not claim any additional maritime zones. So if land only counts as territory when it is inhabited by a permanent population, it becomes essential to define the threshold at which a group of people no longer counts as a population. And to establish a minimum quantitative standard, we can look at the smallest dependent island territory, which has been offered independence by the UN. That's the island territory of Pitcairn, which harbors a population of about 50 people. So from this we can see that the number of 50 people is the smallest number to have been internationally recognized to form a potential state population. And in a similar vein, John Van Dyke argues that a stable community of about 50 people is necessary to distinguish islands from uninhabitable rocks. But in addition to this quantitative standard, there are also qualitative characteristics that characterize a population. A German court that dealt with the statehood of the so-called Principality of Sealand, an old naval base on which some people claim to have set up a new state, said that in order to constitute a population, a group of people must not only have a basic infrastructure at its disposal that enables them to permanently live together, but that they must also have the will to live together as a community. So if we apply these criteria, this means that the island state would still have a population in the true sense of the term, as long as a group of people lived there who were willing to lead a communal life together and who had a basic infrastructure that enabled them to do so. I call this group of people the population nucleus. And this population nucleus of perhaps 50 or so would then serve as the legal anchor to the majority of the population that has relocated, and thereby protect them from statelessness. So if a small island state can maintain a population by enabling a population nucleus to remain on the island, this also means that if some islanders just remained there to take care of a lighthouse or do some other specific task, they would objectively no longer count as a population. But on the other hand, it is unlikely that other states would declare that an island state has become extinct, as long as it still had a government and some caretakers remained on some part of the island. In fact, there already exists an example of a state with a pure caretaker population, the Vatican. All the inhabitants of the Vatican state only live there because and as long as they hold office with the Holy See. But although the Vatican therefore does objectively not fulfill the statehood, the population requirement, it is recognized by other states as a state. So the important conclusion here is that even if the island state no longer fulfilled the population requirement, other states would most likely still recognize it as a state, as long as it kept up the semblance of a population by having some people on the island. The recognition by other states would in this case be constitutive rather than just declaratory, meaning that it would preserve statehood in the sense of a legal fiction. So I just said that other states would most likely be reluctant to declare the island state non-existent as long as it still had a government. Well, the example of so-called failed state like Somalia shows us that in practice, states can temporarily function without a functioning government. For the island state, it would be very important to maintain a government that can defend its interests in the international arena. But the consequences of climate change might force the government to establish itself in a host state as a government in exile. Traditionally, governments have been forced into exile either by internal aggression or by external aggression or internal revolutions. But in both cases, recognized governments in exile continue to represent their state. As organs of their state, they can exercise all those competences that governments can exercise extraterritorially. For example, conclude international treaties, entertain diplomatic relations, or also protect their nationals through consular services or the issuing of passports. And the recognition of an island government as a government in exile would pose no legal problems as long as a population nucleus remained on the island. In this case, the rationale for accepting the government as a government in exile would be new, simply because so far no government has been displaced by climate change, and the displacement would be permanent rather than temporary. However, the legal structure would be the same as in the traditional cases, because the government would continue to represent an existing state. The situation would become more complicated once the last population nucleus would have to leave the island, because the government would no longer represent an effectively existing state. But here again, if other states continue to recognize the state as a state, its government could continue to exercise all those competences that real governments in exile enjoy. The last stated requirement is that of independence. And here opinions are diverging whether this requires only legal or also factual independence. Factual independence means that a state is large enough and has enough resources at its disposal to be essentially self-sufficient. So, according to the opinion that requires factual independence, the small island state would lose its independence as soon as the diminishment of its territory forced it to rely on outside aid in order to be viable. However, most authors say that only legal independence is required for statehood. And legal independence means that a state is not under the legal authority of another state. So, according to this opinion, the island state would remain independent as long as it still had its own legal order and government. And this would be true even if that government was in exile, because governments in exile maintain a fixed set of legal competences, and therefore retain their sovereignty even while abroad. So in a sense, legal independence is a status that is conferred by the international community, whereas factual independence requires the existence of a territorial base. Legal independence can also be granted to other non-territorial entities. In our case, this means that as long as other states continue to recognize the island state, it would maintain its legal independence, even if factually it would be dependent on the hospitality of a host state. So before I turn to the question whether a duty of continued recognition exists, I will say a few words on who has the competence to determine whether a small island state has disappeared. Once the island state no longer fulfills the objective statehood criteria, another state could declare that it no longer recognizes the island state. And the consequence of this withdrawal of recognition would be a bilateral denial of statehood. This means that while relations between the derecognizing state and the island state would end, the island state would continue to exist with regard to all the states that keep recognizing it. But of course, if the majority of states or the international community withdrew their recognition, this would come close to an objective loss of international legal personality. But nevertheless, it can be argued that a state does not really cease to exist until it loses its UN membership. Because as long as a state is a UN member, other states have to treat it as a state when they deal with it within the confines of the UN, even if outside the UN they maintain that the state has disappeared. So the important question then is, when does a state lose its UN membership? It's generally said that UN membership is lost automatically once a state ceases to exist. And this is true for all those states that have become extinguished voluntarily, such as Czechoslovakia or the German Democratic Republic. However, the case of the former Yugoslavia shows us that the general opinion by the international community, and even a clear statement by the Security Council that the state has ceased to exist, is not enough to terminate that state's UN membership if the state still has a government that claims continued existence. In this case, what is required to expel the state is a resolution by the General Assembly, taken with a 2/3 majority, and upon the recommendation of the Security Council. I doubt that enough states would vote for such a resolution expelling a small island state. So, in practice, this means as long as the island state still had a government that claimed continued existence, it would most likely remain a UN member. Oops. I now come to the third part of my presentation, in which I argue that other states have a moral and perhaps even a legal duty to continue island states that have lost their effective statehood. So the presentation so far was based on the principle of effectiveness, which is, according to which all that counts is the factual situation. Does a state have a territory, population, government, and independence? However, the international law of statehood is characterized by a tension between the principle of effectiveness and another competing principle, the principle of legality. Whereas the principle of effectiveness is only concerned with the factual situation, the principle of legality states that the extinction of states must not violate certain fundamental norms of the international legal order, so-called jus cogens norms. And this has been codified in Article 41 of the ILC's draft articles on state responsibility, which states that the consequence of a serious breach of a jus cogens norm is that no state shall recognize the effective situation that results from this breach. So, applied to the extinction of states, this means that if a state is extinguished in violation of a jus cogens norm, other states have a duty not to recognize the effective new situation, but to keep recognizing the international legal personality of the state, although it has factually disappeared. And so far, this has only been practiced with regard to states that have been illegally annexed through the unlawful use of force, such as Kuwait in 1990, simply because so far this has been the only case of involuntary state extinction due to foreign influence. However, in theory, the principle of legality also applies to island states, which are extinguished by anthropogenic climate change. The extinction of island states also affects fundamental international norms, such as the right to self-determination, permanent sovereignty over natural resources, or also the fundamental right to state survival, which has been invoked by the ICJ, although here it's not really clear whether this is a jus cogens norm. But the practical application of the principle of legality to the case of small island states poses some difficulties, because while it is clear that jus cogens norms, such as the right to self-determination, will be affected by the disappearance of island states, it is difficult to establish that other states actually breach these norms in the technical sense of the law of state responsibility. Because the multi-causal and protected nature of climate change, as well as the weak legal obligations contained in the climate regime, make it very difficult to assign legal responsibility for the inundation of an island state to one or even several other states. But even if a legal duty of continued recognition cannot be established, states should accept moral responsibility for their disproportionate use of the atmosphere and continue recognizing island states out of a sense of international justice and solidarity. So, although it would no longer possess the effective insignia of statehood, the island state would then continue to exist as a state, which means it would continue to benefit from the presumption of sovereign equality of states. And this would distinguish it from other non-territorial so-called special sovereign entities, such as the Sovereign Order of Malta, which do not automatically enjoy the same rights and competences as states. The government of the island state, on the other hand, could continue to represent its state in international fora, and it could continue to exercise all those competences that states enjoy internationally that do not require a territorial basis. Most importantly, it could continue to protect its nationals, which would not be stateless, at least de jure. And it could also continue to administer the state's maritime zones, if those were kept stable in spite of sea level rise. And I come to the policy recommendations. So, if the scientific predictions are correct, at some point, low-lying island states will lose their effective statehood. As I've said, this would most likely be the case when the last population nucleus would have to leave the island. So the first policy recommendation for maintaining effective statehood is to make sure that a population nucleus, that is, a group of people that live together as a community, stays on some part of the island, whether this island is artificially protected or reinforced or not. Although the majority of the islanders would have left, this would safeguard the effective statehood of the island state. However, if this is not possible, the island state should make sure that at least some caretakers, some people, remain on the residual island. Because in this case, although the objective statehood criteria would have been lost, it's unlikely that other states would claim that the island has ceased to exist, the island state has ceased to exist, as long as it kept up the semblance of a population. In any case, the island state should maintain a government that claims continued existence. This would most likely prevent it from being expelled from the UN, And in practice, this alone would safeguard its international legal personality. Ultimately, if the international community does not act quickly enough to prevent small island states from losing their effective statehood, the acknowledgement of their entitlement to survive as a legal community is the least that is owed to them. Thank you.
Thank you very much, and we will now hear from Professor Maxine Burkett of the University of Hawaii Law School.
Thank you so much. It's really an honor and a privilege to be here talking on this issue, and especially to participate in such a problem-solving oriented conversation. It's not often that law conferences are so solution-oriented, in fact. So it's really a pleasure. I'm just going to provide a very brief overview of the proposal that I lay out in a paper that I've called The Nation XC2, and it's actually quite, I think, a nice transition from some of the things that Jenny talked about, so I'll be referencing some of that as I continue. But I should first share that I'm actually from Jamaica originally, born in St. Andrew's Hospital in Kingston, and so I've thought a lot about the context of borders and nations and governments and what it means to be a part of that in that context of sort of being a post-colonial subject myself, and so that kind of influences some of what I'm thinking about. But basically, my argument is that to respond to the phenomenon of landless nation states, international law must accommodate a entirely new category of international actors. And that's why I introduced the Nation XC2. An XC2 nationhood is a status that allows for the continued existence of a sovereign nation afforded all the rights and benefits of sovereignty amongst the family of nations in perpetuity. And in practice, this would require the creation of a new kind of government framework that could exercise authority over a diffuse people. And I elaborate on earlier calls. There have been some others who have suggested that that can be done through a political trusteeship system to provide the framework for an analogous structure. And so I do two very different things, quite different things, but inextricably interlinked things in this paper. I first attempt to define and justify the recognition of a deterritorialized nation state, and then to explain the trusteeship arrangement that would form the government of the XC2 nation. I then quickly will describe what it means to actually apply this to a particular nation. And I apply the supposed scenario to the Republic of the Marshall Islands by playing out the implications of the Republic of Marshall Islands XC2, or RMIES. And in doing that, you will see that there is the opportunity to uncover some very thorny issues that need to be sorted through of sovereignty and history that become more clear and really need to be addressed. So first, I just talk briefly about migration, sovereignty, and statelessness. I think we all know some of the background issues there. The relatively near-term dissolution of countries' habitable territory due to climate change, the phenomenon that I refer to as endangered nations or threatened nations, represents a novel question that challenges the very foundation of the Westphalian system that we now live in, the system of nation-state sovereignty. And it's clear here, a trip I took to the Tuamotus, it's clear here very explicitly that we're seeing this relatively rapid threat to endangered nations. And it's also implied here by, sort of ironically, at the COP15, Our Island, Our Future, Tuvalu, for sale. This is very real, this is very present, and we need to do something that is a bit more novel in terms of re-envisioning what we understand to be the state. Deterritorialized nationhood as an alternative future for endangered nations is not necessarily a new concept. In fact, others have contemplated the successor entity. In particular, Professor Rosemary Rayfuse, who's also speaking at this conference, has briefly introduced the possibility, arguing that a more equitable solution may lie in recognition of a new category of deterritorialized state. So far, scholars have introduced this idea but haven't had the opportunity to elaborate on what that means or justify this kind of new category of international personality that I recommend. So we want to re-envision the state. There are three basic points that support creation of a new category. First, alternative forms of the state aren't necessarily novel. There are historical analogs. The analogs are a bit rough, but they are relevant. And I'll briefly point to examples of entities that provide precedent. I then identify elements of cosmopolitan theory, as well as the evolving conditions of various diaspora, that prove that a landless or virtual nation is appropriate and an inevitable evolution of contemporary citizenship and nationhood. And I do this carefully because I don't want to be flippant about it. This is a very different kind of circumstance, an experience of diaspora that is brought on by climate change, rising sea levels, and the experience of endangered nations. But I finally argue that if none of this is availing, the extraordinary circumstances of threatened nations alone justify such a unique departure from the norm. So thinking about alternative forms of the state, there are three existing categories of international actors that provide helpful precedent for the deterritorialized nations proposed. They are countries that have already governed without a territory, or entities that have already governed without a territory, failed states and governments in exile, and economic entities that serve quasi-governmental roles. I'll briefly summarize a couple here, but starting with the Sovereign Order of Malta, which Jenny made reference to. I don't know how many of you are familiar with this entity, but it is actually, it's out there. It has a very vibrant website and probably exists most powerfully in a virtual format. But the Sovereign Order of Malta is a sovereign subject of international law. It's based in Rome. It has its own government, its independent magistracy, bilateral diplomatic relations with 104 countries, and is granted the status of permanent observer in many international organizations, such as the United Nations. And again, if you were like me, you weren't very familiar with what is happening there, they actually have a page for frequently asked questions regarding how they operate, who they are, what it is, how they govern, through Constitution and its code, election for life for the council. They have a chapter general voted on every 5 years. They have a base after the loss of the land of Malta since the mid-1800s. They have been permanently located in Rome, Italy. Provides an interesting example. There's also the recent election of the Tibetan leader, new prime minister for Tibet. 55,000 voted. 50% of the 55,000 scattered across the world voted for a new prime minister. And of course, this is, again, a rough analog in that this is describing a government in exile. And again, admittedly, governments in exile have been contemplated more as a temporary and exceptional kind of status. But I'm contemplating a deterritorialized state that exists in perpetuity, right, subject to renewal by its diasporic citizens. I'll say a little bit more about that in a little bit. But what's important here is that there are lessons that can be learned from this highly disparate community, at the least in terms of mechanics of coordinating this kind of civic participation across many different boundaries and borders. Now, if we look to the second, the elements of cosmopolitan theory and diaspora, both of those ideas have served as a counterweight to neat understandings of statehood, land, and citizenship. In fact, that's what the scholarship is about, is really trying to upset our notion that the two or three are inextricably intertwined. So while this is the map that's relevant to us for the purposes of a changing climate and certainly the science of it, this is the world that we live in. Borders are superimposed. Non-natural legal structures are what govern. And in some cases, those legal structures can exacerbate the experience of climate change. But these are not laws of physics. These are laws of society and humanity. In some ways, we can find some comfort in that they're hopefully more forgiving than climate change will be to the physical world. So contemporary global movement forces us now to rethink beyond the nation, traditionally marked by borders and dividing walls. And indeed, the experience of diverse and multiple diaspora make the cosmopolitan framework uniquely relevant for the 21st century experience of land and state for groups and for individuals. And so under this rubric, it becomes clear that deterritorialized nationhood is not far-fetched. In fact, there may already exist a rough blueprint for its theoretical and normative infrastructure in the diverse scholarship of cosmopolitan theory. And in particular, post-colonial migration has produced a different and specific kind of citizenship. While citizenship is generally understood as territorially bound, post-colonial citizens are deterritorialized and maintained through, among other things, travel, pilgrimage, labor migration, and complex residential patterns that traverse boundaries. Further, territorial boundaries and national identity poorly reflect the kind of global migration that has produced citizens that exercise substantive citizenship in at least two states, as well as citizens that enjoy long distance bonds with nations from which they've long immigrated. So indeed, the post-colonial diaspora describes a present tense experience of deterritorialized nationhood, and in these experiences, transboundary solidarity trumps the legal and political boundaries that we see. And so, in fact, I was very close to bringing both my Jamaican and U.S. passport here to show you, as I often actually, whenever I leave Hawaii, I feel like I'm coming to another country when I get to the continent. But an example of this is that if you take the Jamaican experience as one to sort of use as a current model of what diasporic experience is, we have here a population within the country that's about 2.9 million, and a diaspora that is, depending on the source, between 1.9 to 2.6 million across the world. And the Jamaican experience is quite rich and quite meaningful in those disparate places. I think that there's a story there that can be relevant. There's a story about transboundary allegiances to people and culture that, again, go beyond substantive citizenship as we understand it today. I think that this is also an example of how the Pacific experiences as well. If you see here, this is just, actually the updated numbers aren't out yet, but this is U.S. consensus numbers for the Pacific Island populations. And we see that there are significant populations in the United States today that have a rich experience of community. It's true in the U.S., and I'm certain it's true in Australia and New Zealand and other locations of the diaspora. Again, the analogy is not complete. For most members of the diaspora, the existence of a tangible home remains, even if one never makes a visit home. In other words, there is still a land, there is still a territory to which to return. But for purposes of this international discourse, the trend of dispersed residences and transboundary loyalties has already disrupted, again, this neat correlation between citizenship and residence or territory. And to the extent that that condition was ever firm, international law, I think at this point, should affirmatively consider abandoning territory as a requirement of statehood and meaningful citizenship in light of the changing climate. Finally, if the above is not persuasive, the alternative forms or the use of theory in diaspora, extraordinary circumstances seem to suggest that there should be a reasonable interpretation beyond what we understand today. The presumption in international law for continuity of an existing state would logically extend to the current endangered nation scenario. Similarly, appropriate interpretation of existing laws and the spirit in which they were drafted and ratified militate in favor of expansive interpretation for the benefit of peoples of endangered nations. So if we go centuries back to the purpose of the Peace of Westphalia, for example, which was ostensibly to provide security and stability represented by borders and nation states, allowing the deterritorialized nation bound by culture and experience to maintain a place in the international community would meet the objective purpose of the Westphalian system at a time when climate change poses an extraordinary threat to both territorial integrity as well as global peace and security. So what are we looking at in reality? The ex-situ nation is a means of conserving the state and holding the resources and well-being of its citizens in new locations in the care of an entity acting in the best interests of its diffuse people. Other scholars have suggested a resurrection of the political trusteeship system as a means for administering the duties of a deterritorialized government. So here I elaborate on that system and provide a structure that provides a permanent space for long-distance and perhaps collaborative governance of nations ex-situ. Some of the key features. Trusteeships generally, the trusteeship arrangement has been a consistent feature of international law. It's modeled on a common law trust. Political trustees administer the territories they hold in trust for the benefit of the inhabitants of that territory. It's a structure that the international community can most easily replicate given an earlier experience of the United Nations in particular. It's usually to establish self-government, but I argue that to respect the continued sovereign equality of the endangered nation, the United Nations and member states must act to support the transition to an establishment of ex-situ nationhood. In practice, the United Nations might establish an office with the express purpose of facilitating the transition and long-range governance of endangered nations, all of whom are marked by their limited resources. A secretariat would serve as the locus of United Nations administrative support and might also serve as a hub for all nations ex-situ to work collaboratively and synergistically for the benefit of current and future generations. I also argue that appointed members of the endangered nations supported by the UN would serve as the political trustee. At first, the trustee would serve as an interim body that governs alongside the existing in-situ government of the endangered nation, and that would facilitate an orderly transition for the peoples and governance mechanisms of that nation. the United Nations could help establish and other states recognize the interim mission of a given endangered nation. So, for example, there would be the interim mission for the Republic of Marshall Islands that would serve as the authority to administer all provisions related to the transition of the endangered nation from its current status to a purely deterritorialized entity. And the decisions of that the interim body might make include enactment of legislation for continued citizenship, as well as distribution of monies from resource rents, adaptation funding, and/or compensation from other international entities. And this is key, I think, and I can elaborate on that in the Q&A. But with respect to compensation, there's an opportunity here to have an entity that can actually receive that and administer it and distribute it. I think the most significant element as well is that this would be an opportunity for an exercise of diplomatic protection of the diaspora as they reside in their sovereign host states. So there's an opportunity for a body to advocate on behalf of the protection of the dispersed community. So there's an establishment of interim mission and the status of permanent nation ex situ that must occur. Once the moment of territorial dislocation occurs for the relevant population, and those markers would be something that Jenny has talked about, the interim body would combine with the dislocated governing body to form a single locus of power. And while this new body would be distinct in name, the manner in which it operates, namely for the benefit of its people, will be almost identical to the interim body. And in this sense, the new ex situ government is an element of their overall trusteeship model in that the nation ex situ will serve the function of coordinating all social, economic, and commercial matters related to its former territory for the benefit, again, of its dispersed citizens. And finally, I think it's important to say, and as succinctly as possible, that this should be member-driven. In other words, the endangered nations electing to participate and their citizens will determine the specific terms of the trusteeship through iterative processes of evaluation and amendment. It is important to note that a key element of the agreement is that though this ex situ nationhood is designed to exist in perpetuity, it would be and should be subject to a decision by its members of the disembodied nation to dissolve at any time, and certainly to make decisions short of that in that time period. I think there are several benefits of this opportunity. First, an identity based on formal membership can be passed down through generations. Even without a physical location, the sense of bonded community will continue to have multi-generational relevance and strength. Second, I think the nationals of the ex situ nation can continue to enjoy a shared purpose. Indeed, this appears to be the most powerful binding force of the sovereign Order of Malta, whose members remain bonded by history, spirituality, and service. And the possibility for reunion in other locations is a third method for continued cultural identity. Of course, the means by which the diaspora maintains its lifeways through ex situ nationhood is, again, the decision of its members alone. Oh, excuse me. So now if we were to look at what that would mean, in reality, the palpability of the potential future would be judged, or should be judged, against historical experience with trusteeship systems. And as Mike had mentioned this morning, there is a long and extensive experience that the Republic of the Marshall Islands has had with external administration, and a very short history of independent statehood, which itself is colored by the unique nature of the Compact of Free Association. That history may militate in favor of a return to familiar trusteeship arrangements with most likely the United States. Alternatively, a further amendment of the compact that contemplates self-governance and free association with the U.S. with specific negotiation around eventual loss of territory and resettlement may seem appropriate. However, even if the United States were to absorb the population of the RMI and the U.S. further chose to vigorously represent the interests of the Marshallese, it seems the existence of the Republic of Marshall Islands ex situ would remain necessary as a practical matter. The U.S. would need to maintain a relationship with some specific entity for the compact or trust arrangement to have any meaning. In this case, it would most sensibly be this ex situ nation. So, to conclude, I mentioned that I am from Jamaica originally. I was once at an Oceans conference a year ago, and a number of us were sort of wringing our hands about what to do to make this climate issue really palpable and understood for the rest of the world. And one of the scientists on the panel suggested that we link this to our kids, our pets, our house, our jobs, some things that really tug at the heartstrings. And it just so happened in that particular presentation and here, my daughter Meridian seemed to be relevant. And here she is at a beach in Waikiki, and there just seemed to be such great irony in how joyful she is with her feet covered in water, and that really struck me. And as a student, as I said, of post-colonial theory, a daughter of a colonial subject, and an immigrant from a former British colony, I've always sort of hoped for a rethinking of the Westphalian order, sort of a progressive redrawing of the world's maps, if you will, where borders and boundaries would be fundamentally questioned. And that fundamental questioning may well come to pass very shortly, but under wildly different circumstances than I could have ever imagined, and I imagine the rest of you as well. And now I find that we're here searching for these borders to be saved and these imagined communities to persist for the sake of all of our children. And so I thank you for the opportunity to talk about this, and I welcome a pretty vibrant question and answer to figure out where we go next. Thank you.
Thank you very much, and I'd now like to call upon my distinguished co-chair of this conference, Ambassador Philip Muller of the Republic of the Marshall Islands.
Thank you, Professor Gerard. Before I start, I wish to just join my foreign minister in thanking all of you for coming to the conference. We think this is going to be a groundbreaking conference, and we look forward to your active participation. I also wish to take this opportunity to thank my colleagues at the United Nations. We have a number of ambassadors with us. We have Ambassador Decima Williams of Grenada is in the back, Ambassador Marlene Moses of Nauru, Ambassador Thompson of Fiji, Ambassador Lima of Cape Verde, Ambassador of the Maldives, Ambassador Mohammed, and I think there is some in the back. The DPR of Cuba is with us also, so thank you all for honoring us with your presence. We have just listened to the presentation on the legal side of the question of statehood and statelessness. But let me speak from the political side. And the fact that we need a conference to contemplate the legal aspects of threats to the existence of states is not something to celebrate. It is indeed a recognition of a big failure. At this present time, the international community is failing to tackle climate change with the urgency and determination required. We have not yet found the necessary political will to deliver the ambitious response required. The legal framework for the discussion of climate change under the UNFCCC, unfortunately, is not working well. 2 months ago in Bangkok, the conference spent 1 week discussing the agenda, discussing what to discuss in the actual meeting. That was, everybody's nodding. The sense, that's what I mean when I say the sense of urgency is no longer there. Already today, there are a number of countries asking us to support their hosting of the next 3 COPs 3 years from now. So there is no light to the end of the tunnel. And I think that was why I approached Professor Gerard. I said, the current system is not addressing the urgency of the need to discuss sea level rise and climate change. This is an important issue. The current framework does not include our major contributors to the emission of greenhouse gas. So even if we reach a legal agreement sometime soon, which I don't think we will, the major players are not in the process. We need to get the major players to be in the process. We are determined to find a way to, one, while also boosting our own resiliency. At the United Nations, we operate on the basis of sovereign equality. one nation, one vote. But when it comes to the impacts of climate change, there's a whole different standard. And in this first panel, we have chosen to tackle the most difficult and sensitive questions of all. What to do about the prospect that we may be causing climate change of a magnitude that could literally wipe nation states off the map. Should we redefine how we draw maps? We may be looking at prospects for redefining the nation state, yet we do not currently have a well-agreed and clear definition with which to start. For the Marshall Islands, the situation could not be more serious. We have just heard this morning a description of our low-lying nation, with atoll so narrow you can see the lagoon and the ocean on the other side. And we have heard of the range of impacts which the long-term future may well hold. Unfortunately, our range of response options is limited, and thus statehood is a direct issue. Retreat from the coast to higher grounds is not an option for the Marshall Islands. There is no mountain in the Marshall Islands. It's a narrow island atolls. We have no higher ground. We are committed to implementing a menu of concrete actions to, among other goals, ensure our resiliency, but these are perhaps not necessarily a full and complete guarantee of survival. To complicate matters further is the fact that our Marshallese cultural traditions place a unique emphasis on our land, and it is tied closely to how we defined our statehood. This is contained in our preamble of our Constitution. For us, land is our identity, not an interchangeable commodity. That is a cultural identification, and perhaps also a legal principle. Our land, the environment, and our natural resources, particularly marine resources, are the center of our life and part of the Marshallese collective culture and identity. Therefore, the impacts of climate change on our islands will need to be addressed not only as an issue of sovereignty and territorial integrity, but also as a threat to our identity as a people. It is not so much an issue of individual statelessness, but one of a threat to our collective statehood and national identity. We have heard from previous speakers how the impacts of climate change, in particular sea level rise, may affect the constituency elements of statehood, including a defined territory and a permanent population in habitation of that territory. These criteria are not static, and the gradual and cumulative impact of climate change means that predicting thresholds for ongoing habitation of a country is very difficult. As noted by the UN High Commissioner for Refugees, some low-lying island states are likely to become uninhabitable long before our full submersion. For each country, and indeed parts of our country, the timing for consideration of a different option differs. But for the first time in history, we are contemplating the disappearance of a state without the possibility of a successor. We have heard original proposals relating to the territorialized or ex situ nationhood and the possible obligations of ongoing recognition of these successor entities. There are certainly some compelling ideas which perhaps attempt to overlay an understanding of some of the core and traditional political elements of statehood across a future for which there is no or very little precedent. But it is important not to frame this discussion merely in terms of a long-term legal implication, but also the legal framework applicable to the causes of the problem and the principles governing relations between states now. It is the view of the Marshall Islands that the threats to statehood posed by greenhouse gas emissions and the resultant climate change strike at the core of some of the fundamental legal underpinnings of the international system. For example, a climate-driven threat to statehood, in our view, cuts across the legal rights to territorial integrity and non-interference, as well as the right to political independence and self-determination and permanent sovereignty over natural resources. These rights and obligations have been captured and developed over the years in the UN Charter. Successive resolutions of the Security Council and the General Assembly, the International Governance on Human Rights, and the jurisprudence of the International Court of Justice, they have become part of the corpus of customary international law. The rights to self-determination and political independence are still fresh in the minds of our political leaders in the Pacific region, many of whom were involved in the decolonization struggles for their peoples. Most of our Pacific Island neighbors emerged as independent countries in the last 30 years or less. For the Marshall Islands, our independence came only 25 years ago. Political independence is something that my generation and my mentors fought long and hard to achieve. The memories of trips to the United Nations, struggles in translating trusteeship to sovereignty are still fresh. There is a sad irony that the youngest generation of Marshallese may be equally challenged in defending, if not maintaining, such statehood. I would argue, therefore, that as we contemplate a future that might challenge conceptions of statehood as currently formulated, there should be no burden or pressure from the international system and its legal frameworks on those who have done nothing to cause the problem. This is consistent with rights to territorial integrity, self-determination, sovereignty over natural resources, and the obligation not to interfere with or undermine those rights. The core elements of statehood and its related rights must be retained to the fullest extent possible in all eventualities. This is, after all, what permanent sovereignty and self-determination are all about. Thank you very much. At this time, I would like to invite Ambassador Lima to share some of his thoughts before we open up for question and answers. You can do it from there. You can come up here. I think it's better to come up here.
Well, thank you very much, Ambassador Muller. Let me just begin by saying that a lot of people think that the sacrificed lambs are going to die without shouting. I can assure you that we are shouting. We are screaming, but we are shouting. Because it is not, for us, the small island developing state. It is not a future for us to predict the disappearance of our islands, to predict the disappearance of our culture, and to predict the end of our history. I think that the exercise we are doing here today, it is to try to give to everybody the sense of surviving of these islands. It is not only a political exercise. It is not a university exercise. It is truly to reflect on the causes of the situation we are living today. Of course, we can discuss the consequences of what we are living today, the relocation of population, migration, etc., as we heard this morning. But what is the main situation of all these islanders? I say all because I believe in solidarity. We have mountain in Cape Verde, and perhaps we should prevail for some years. But if we are not able to be solidar with those who are going to die tomorrow, with those that we are talking, they are going to disappear or to need to invent their own future on other land, if we are not able to be solidar with them, what can we expect from the world? What can we expect from the future? Because I think that all the islands at this moment have to be on the same level of responsibility, on the same level of action. We are dealing with the survival of our people. It's not only the remaining government of a state. It's not only the disappearance of territories. It is the survival of nation. These people are bringing to the world, to the civilization, unique cultures. If they disappear, some of our universal civilization is threatened. And if we are not able to give them the possibility to have hope in their future, are we going to have hope on our own future? I doubt that. Because civilization doesn't mean to abandon those who are going to die to their faith. Civilization means solidarity and humanism. And I think that it is not a political issue, this. But the fact is that what we are seeing at this moment, as Ambassador Muller said, is that the negotiations on climate change are not going far enough, are not going fast enough, and in the meantime, some of us are going to be confronted with the end of history. And this is the main issue. What can we do to decrease the gas in the atmosphere? What can we do? This is the main thing. Of course, we can think about the results of the situation. But to resolve this situation, I think that we should all continue to struggle for 1.5 degrees Celsius in the air. Of course, we heard this morning and we heard the other day at the German mission, some scientists saying that, oh, you have to prepare for 3 and 4 degrees. How to prepare for 3 and 4 if 1.5 is affecting us so dramatically today? I don't think that some of us are going to be in the same Columbia University hall in 2100. So if we are not united to struggle, if we are not united to understand that, if we don't take the point of view of the seeds as the essential of our common survival and the survival of the planet, we are not doing the right thing. So there is consequences politically, and there is consequences on populations. Can we be solidar with this island who are going to disappear? Can we be solidar with our own children who are going to suffer about that? Because if they are only the first to go, we are the sentinels of the world, the small island developing states. We are the sentinels of the world. What is happening to us will happen to all of us tomorrow. And if we have no sense of what we are doing today, and if we don't insist with all the government in the world to tell them we have to save these guys, because if we don't succeed to save them, we are condemning ourselves. Because tomorrow we will do the same for ourselves. It is not the law of the barbarians. We are in the 21st century. So please, we have to respect the others, we have to respect ourselves, and we have to try to save all of us, because we are from one sense or another, linked all together. Thank you.
Thank you very much. We have time for questions. Yes, sir. Yes.
Thank you. I'm Fred Soons, Utrecht University School of Law. I would like to thank the panelists for their excellent, fascinating presentations. And the emphasis, of course, was on, in fact, in the first two presentations, either on how to maintain the state or create an alternative form of governance. There was less focus, I think, later on we got some more information on that, about why to maintain the state. And of course, most important reasons are the socio-cultural reasons, as I understand. There are also economic reasons, and in the panel after lunch we will deal in more detail with these economic reasons. But perhaps some more could be said about these reasons, because I think that if you want to convince the world community to accept ways in maintaining these states, notwithstanding the problems that have been identified, you will have to indicate exactly why and for what purpose and what the objectives are for maintaining those states or alternatives means of government. But I would like also to ask the panelists perhaps to comment on two other alternative, perhaps more traditional methods to maintain the state. One would be that a current threatened state would, by a treaty of cession with another state, acquire territory which is not threatened by sea level rise, so that at least that element of statehood is safeguarded. Maybe this is not very realistic, but at least in theory the option exists. But the other option might be more realistic, and that is a merger of, for instance, a number of Pacific island states, of which, of course, at least one would need islands that are not threatened by sea level rise. Of course, then you create, in fact, a new state, but at the same time, for instance, if you have a federal state, I think you could ensure the maintenance of, in fact, many of reaching the objectives of maintaining the state, the objective that I mentioned earlier, by means of having another state which incorporates the previous states. Thank you.
Thank you for your comments. From an ethical perspective, I think it's pretty obvious why we should maintain the statehood of those island states. They presently exist as sovereign nations, often after long struggles with a colonial past, and they want to maintain this status which provides for them the ability to be full-fledged members of the international community. So, to translate this in more legal terms, only states have plenary competences of international representation and the automatic right to participate in these international fora on an equal footing. And to refer to the population, currently only states have the ability to confer effective nationality. So only if the island state kept being recognized as a state could its people maintain a nationality. Whether this is necessarily effective or not is a different question. And the third point that I would like to emphasize is the maritime zones. Under the current law of the sea, only states can administer maritime zones. So in order to safeguard for these island states at least one economical basis that might not be affected by sea level rise, it would be important to safeguard their maritime zones and make sure that they can still exercise sovereignty and sovereign rights over them. As to your second question, whether cession or mergers would be good alternatives, I think they're legally viable. Certainly, cession would safeguard the effective statehood of the state if another state transferred full sovereignty over territory. I didn't address it in my presentation because, as you already alluded to, I doubt that it's politically viable or likely. Even if another state was prepared to cede territory, this would cause grave legal problems if that territory was inhabited. What would happen to the population that currently lives there? If, on the other hand, uninhabited territory is ceded, it's not likely to be very valuable in terms of economic resources or livelihoods. So those are the practical constraints. And from a legal perspective, for archipelagic island states, it might also be difficult because if they got ceded land from a continental state, they might lose their right to draw archipelagic baselines because they wouldn't be an archipelagic state anymore. So, and the same considerations basically apply to a merger with another state. I think this is a legally viable strategy. I just do not envision that this is a politically acceptable solution to most states. Thank you.
Thanks for those questions. Here we are. So first, to why to maintain the state, and in fact, a number of my No Borders colleagues were like, "Why maintain the state? This is a perfect opportunity, in fact, to sort of dissolve this notion of these firm state boundaries." And of course, I know that's not necessarily the spirit behind your question, but there is an opportunity here to really consider what we mean and what the value that's conferred when we continue to organize in this way. But in this particular context, I think it's important to echo what our ambassador said, which is that there's an incredible amount of importance in the land and the territory. And I didn't address that in my talk, although I do in the paper, but there is a very critical relationship that many in the Pacific island community have with the space that they're in. And what we talked about doesn't involve the territory because we know that that's what's threatened. And as I was writing and researching, it was with a very heavy heart. It was the acknowledgement of the fact that this very key part of existence and identity is going to be lost. And because of that, the closest sort of consolation, if you will, is that there is some opportunity for there to be an undying relationship amongst the people that were from this particular land. And so in sort of there's an ethical argument to echo, in sort of a social sense and the sense of bonds and connection, there's a really important reason to maintain the state. But then also the mechanics of the state, again, having an opportunity to participate in the international community, to exercise one's sovereignty is really key. And there are very specific things that a continued state would need to do. In addition to thinking about maritime boundaries, again, it's that who gets the adaptation funding, who gets when we're talking about resource rents, how is that distributed? The simple mechanics of it require some sort of structure, some sort of government entity to continue that. And if you have an infrastructure for that represented by the people of that nation, there's a real opportunity there to do it well, to facilitate that transition in both the long-term existence well. Also, again, just to echo this, the diplomatic protection that will come from having a state that's looking out for this very diffuse population, but still actually having that as a primary concern is something that I think certainly supports the maintenance of the state. With respect to the alternatives, again, I want to echo a lot of what Jenny was saying about feasibility, politically speaking, but also coming from sort of a climate justice perspective and thinking about ethics and thinking about vulnerable populations. There's a real sort of reflexive concern about relocation issues and creating other communities in a particular place. And I think about the Native experience in the United States, the possibility of relocation. If you were to get a patch of land that has any sort of quality to it, which I think is probably not going to happen, if you did get that, then you still have a concern of what it means to be a part of another sovereign nation. In a sort of reserved and relocated space, a finite space, and whether or not second-class citizenship issues will kind of determine how you experience your citizenship absent some other kind of recognized citizenship as well. That's a concern.
Let me just add a couple more thoughts. I've just been through telling us how important the land is to the people. We are part of the land. And to move people off of the land is going to be a very, very difficult one. But I think the question that we need to address now, if we have not in fact reached the tipping point, the point where things will not be reversible, If we have not reached that point, I think the question we should ask is, can we save these countries? What can we do to save these countries rather than thinking about moving them or making them part of another territory or relocation? But I believe there is still time. And if this conference or the international community has the political will to tell the biggest emitters that there is still time to stop doing the activities that create the greenhouse gas emissions, I think we can do that. So I think it may be, it's relevant to discuss those issues, but at the same time, I think we have to keep in mind that the pressure must be put on to continue to save, to try anyway, to save the low-lying island states. Thank you.
Other questions? Yes, sir.
Thank you. Dennis Momotaro, Senator, Republic of the Marshall Islands. Not going to make some questions, but I just want to bring us to some attentions. And you mentioned earlier that 67 atomic bombs were tested in the Marshall Islands. And if we look at it before the bombs were tested there, you know, our people were told that the bombs would be tested for the good of mankind. Now, after the bombs were tested until today, our people are still being affected and being sick from all the affected from the bombs until today. Now, here we are talking about climate change, and this climate change, you know, it was not also started from us. And I agree with the ambassador that mentioned that, you know, the world international community must do something now instead of waiting until, you know, all these island states will be, you know, submerged and under the sea. If we also look at it, you know, we know there are endangered species, and like the whales and other animals like the turtles, you know, when they're endangered, the international community, you know, they really come to their attention and try to do something. But I feel that also our island states, small islands, and the core islands, we are also in danger, especially the people there. So I think, you know, the international community must also try to take actions and also try to help our people. As I mentioned, I'm not going to make questions. I just want to bring our attention to some of the things that our small island states are experiencing now. Thank you.
Thank you.
Can I quickly just respond to that? I do want to say that well, this sort of the first draft of what I was writing really was just a quick sentence that said, optimally, this won't come to pass. We'll do what we need to do in order for this to not occur. And in fact, in thinking about a lot of the consequences of losing an island nation, I did very much think about what would happen if, as a member of the diaspora, there was no longer a Jamaica in which to return, right? This is a very different kind of future to contemplate. And so again, it was with a very, very heavy heart, you know, I conducted the research and thought about writing in terms of what this other nation would look like. And in fact, one hopes that this research sort of falls into obscurity, that we won't need it, that it will collect us like many other law review articles have done. So that is absolutely my hope, and I think that this conversation should not cast too long of a shadow in terms of what we have to do simultaneously with respect to pressuring governments to act swiftly to reduce our emissions. So I just want to share that again in solidarity as a nation, an islander as well.
Thank you, both panelists, for your very informative talks. I thought that your arguments about the maintenance of existing nations were very persuasive. There are lots of situations across the world where peoples claim statehood but on disputed territory which is currently held by other states. I wondered, to what extent do you think that the probable experience of the world as regards island nations disappearing but continuing to exist without territory would have a bearing on the creation of possible new states? So could new territories and states be created outside of the traditional Montevideo criteria?
Yeah, that's a good question. I thought a lot about that as well, because there's that slippery slope concern about whether or not you, by accommodating this new kind of international personality, then you're opening it up for other opportunities that may themselves have merit, but you want to be concerned about doing something that is very neatly defined. And I actually think that it's very it would be probably the best way to proceed would be to have some sort of formal treaty or resolution that recognizes this particular kind of circumstance and defines the boundaries of that pretty clearly, so that there isn't that initial concern about there being follow-on consequences of this departure from sort of the typical nation-state definition in the Montevideo Convention.
Yeah, actually, I was thinking about this too in the context when I was wondering who would object to the maintenance of a deterritorialized island state. And apart from direct resource interests by individual states, that was like the only conclusion I could come up with, that states are jealous to guard their monopoly of representation and statehood in international organizations. And I think the one concern would be to actually open the gates to other non-territorial entities once you accept deterritorialized island states. We've seen the opposition that states had to just even granting observer status to the PLO in the UN. So this fear of opening the gates to other entities would have to be contained or overcome in order to for this to be a possible solution.
Thank you very much. I'm Martin Svakula with the Micronesia mission. So we are the neighbor of the Marshall Islands. First of all, I would like to thank all the organizers for bringing the conference together. It's certainly very timely to start thinking about the future in respect to how do we keep statehood, both in terms of legal and later on. I think there is a segment also on the physical, on maintaining a country physical by engineering options. But there was one issue that I was hoping, which was raised by the panelists, and if I could ask maybe to elaborate a little bit more on it, which would relate to if you have a country that has no more territory, maybe an exclusive economic zone, maybe not, but that would still try to fulfill the functions towards its citizens, may they be displaced or wherever they might be. That is something that would normally obviously cost a certain degree of money. If you have a consulate somewhere, if you have a mission to the United Nations, that will certainly come with a price tag attached. You mentioned a couple of scenarios of how funds could be raised in that respect, but how do you see the possibilities of an entity with even more limited resources of being able to maintain those functions? Thank you.
Sure. I did think a lot about that, because it seems to me that obviously there are costs that are going to come with the administration of it. So core to the idea of having this ex-situ nationhood status, you'd have to have some sort of administrative support for that. And again, that's why the trusteeship system seemed to be helpful, in that there is precedent for there being some sort of infrastructure that would support the continuation of governance for these often transitional entities. And so I do think this is would be something that the United Nations would offer, as well as members of the international community by agreement. But I also think that there are arguments, and I've written about this elsewhere, for there to be, as a means of compensation, support for this kind of transition and long-term status. So the details of it would be yet to be hammered out, but I do think that there's an argument, at least again ethically, in terms of making sure that the transition matches sort of the highest emitters being able to support those that are most impacted.
Aloha, my name is Leon Siu, Minister of Foreign Affairs from the Hawaiian Kingdom. Thank you so much for this presentation. It is stirring up many issues that we really need to deal with as far as island nations, and we really support the Marshall Islands and thank them for the initiative that they've taken in this area. I think there are several aspects of the discussion that we haven't touched upon yet, and particularly when you talk about governance and about maintaining an identity as a nation, this is really important, very important, not only to us, but it's important to other people around the world as well. It's about time we have this discussion, because what happens when, say, another nation comes in and displaces your people? And talking about, say North America, where you have many Native American nations that have been displaced and have actually lost control and lost power within their own continent. There is I'm not sure if you know about it, but there's some talk going on in America about the possibility of a virtual nation, and that is Native Americans have found themselves totally marginalized in the area of governance or having a voice in governance. So the idea would be to create a virtual state of Native Americans, so they would have representation in Congress as a state, and thus being able to participate in the governance and self-governance. But the other issue I wanted to raise has to do with the area of economics. And the reason for maintaining sovereignty over one's territory is not the territories in the Pacific is not defined by just the islands, but it's defined by this tremendous economic zone around each of those islands. And this economic zone is now, because of world conditions, becoming much more important to the world. So to have island nations maintain not only their identity, but their sovereignty over the governance of this tremendous resource, and I'm talking about food resource. Already, these islands produce much of the world's food, seafood, that come out of that area. But there's also the possibility of energy coming out of this area that can be produced, which would be regenerated energy. That is, because of the global warming situation and the warming of the Western Pacific, it makes an ideal situation for these island nations now to benefit from being a participant in the creation of energy for the use of the globe. So I think that this is another strong reason that finally the Pacific Islands will be able to actually contribute significantly toward the global economy because of these resources that they have. And I think that's one reason why their sovereignty needs to be maintained.
And I'll just mention that the panel right after lunch is going to focus on the economic zone and some of those issues.
I appreciate very much the comments about the need to reduce emissions in order to avoid facing this terrible problem. And I also appreciate very much the desire and value of maintaining a defined state, ex situ, for cultural and economic reasons, as well as the reasons for administration that have been referred to. However, I'm not clear how this can in fact become a reality if the nations, the host nations that have to voluntarily agree to accept resettlement populations don't agree with it. And for the reasons that the last questioner mentioned, I wonder what arguments you could advance to the host countries, not to the islanders themselves, but to the host countries, that recognizing an ex situ state with some authority over its residents would be in that host country's interest. It seems to me most host countries will resist that rather strongly.
And let me just point out that the first panel tomorrow morning is actually focusing on the resettlement and migration issues. But would you like to?
Sure. Yeah. Thanks. Thank you for that, Mike, because I did try to sort of, in thinking about the boundaries of what I was working on, not think too much about what the resettlement issues would be like, and what we'd have to consider in that, and the details of it. But this question was really critically important, and I need to spend more time on it. But in thinking about the experience of the host nation, the first thing I think is that I always think it's the right thing to do, and that a lot of these host nations that are contemplated are the largest emitters. If we're thinking Australia, we're thinking Canada, we're thinking the United States. It seems to me that this would be a very minor concession, all things considered, to allow for there to be this continued ability for this nation, this landless nation, to exist, and allow for that connection and diplomatic protection to occur. But also, this happens all the time. I mean, there's multiple citizenship enjoyed all the time currently, with governments, with individuals and communities having relationships with governments that aren't where they necessarily exist, but they can travel under those circumstances. They can appeal to them for various reasons. In some cases, they can even vote in these other countries, in addition to having multiple citizenship. Now, whether or not that's what the issues are there are wholly other, but it seems to me that this kind of extension of an existing arrangement is not necessarily too difficult to imagine, and to the extent that it might be for anyone, you could simply argue that that it's the right thing to do. This is the best way for us to allow for the existence of a continued relationship and partnership and presence in the international dialogue and discourse.
You also asked how this could become a practical reality. So I just wanted to add that there is actually some precedents already for deterritorialized states, which are also based on considerations of legality. For example, there are certain national liberation movements that have been recognized as governments of sovereign states, although they do not exercise any territorial authority. And a case in point is the Sahrawi Arab Democratic Republic, which claims the Western Sahara, which is currently occupied by Morocco. And the Polisario, the National Liberation Movement, is by many African states recognized as a state, although they have never actually exercised authority over the Western Sahara, based on their right to self-determination. And they declared a sovereign state in 1976, and since 1884, they have been members of the African Union. So this shows that deterritorialized nation can actually be active participants in international legal affairs. And as to your question as to the incentive of the host state, well, Professor Rayfuse has mentioned that the maintenance of the exclusive economic zone can provide a continued economic income for the relocated population. So if that population agreed to share a part of this income with the host nation, that might be a possible economic incentive. Whether this outweighs the political reservations that states have is of course a different question.
Oh, I'm sorry. Ambassador Desmond, did you?
But thank you, since you have given me the opportunity to say how much I have enjoyed listening to the four presentations. The concept of effective statehood is very persuasive, well argued. The idea of the 21st century status of populations as we are doing boundary crossings, I think that is also very interesting and real, both as diaspora people and more traditionally the whole concept of migratory patterns among island people. But I want to say that I vigorously disagree with this notion of, I don't know, I'm in the back, I'm not sure if I heard it right. If I did, I don't agree at all with this option of trusteeship as an option to be put in front of us now. I think, as somebody has said, we fought for our independence, we value it, we exercise it, we need it, we share it, and we are not willing to trade it in. So I think this is something I will want to speak more about later, but I don't think it will appeal to most people. You heard Ambassador Muller says that not only is the land of its own intrinsic worth, but it has meaning and grounding in the culture and in the psychic of the population. What I think I'd like to stress is for us to go to the heart of the problem before we come to the legal resettlement of the populations and the legal salvaging of our islands. I think across the islands we are concerned about the reduction of the greenhouse gas emissions and what kind of legal girdles and legal obligations we can put on that. I would like the panel to discuss that a bit. I know maybe there is a special panel addressed to that theme. But just to posit here that in all of our discussions, as ambassadors have said, we need to visit seriously in a legal as well as a political and ethical manner the question of what is the fundamental cause of this problem that we are anticipating, and I think some attention on the legal impact of the reduction of greenhouse gas emissions. And lastly, let me say that all of us who have come to this fabulous conference would want to reflect on what can each of us do as consumers and producers of the problem. Thank you.
Okay. So with respect to the trusteeship question, I should apologize because I may not have been as clear in my presentation as to why I call on that. There were prior calls for a trusteeship system. I think the trust, the trust and trusteeship structure would be helpful, but the very key difference in my proposal is that those that are managing the trust that are actually members of the endangered nations. And they are going to be the ones that make the decisions about how the trusteeship is structured, how it continues, what the transition looks like from the intermission to a permanent state. This is not a trusteeship that would be run or governed or major decisions made by the United Nations or any other community or body or a group of nations in any way, shape, or form. In fact, the relationship that's key is that the United Nations and other members of the international community serve only a role of support in literally both resources, the cost questions about how you actually do this, providing the building in which it administration and governance would occur, and then even issues of how you allow for the mechanics of elections to happen with a dispersed community. That kind of help, just the very ministerial experience of running a nation would be the role of others beside the endangered nation. Again, this endangered nation would provide the membership, the guidance, the drive, the continued existence of the nation itself. That's very, 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 very important.
Let me just add to the discussion on the trusteeship issue. Some countries, like the Marshall Islands, we've had some bad experience with trusteeship. In fact, the fiduciary responsibility under the trusteeship system was violated in many instances. The trusteeship agreement or system is supposed to be helping the people to grow up and to be able to stand on their own and become independent, I guess, but that did not happen in the way that we had anticipated. And in addition to that, the UN trusteeship system was set up in a way that also allowed the United Nations itself to allow the nuclear testing to go on in the Marshall Islands. So that violated the fiduciary responsibility of the administrating authority. So I think I agree with some of the comments that the discussion of having a trusteeship or something is not really something that we would welcome. Maybe call it something else. I don't know.
Yes. Okay. I think that's. I absolutely. I think that's fair. In fact, the only way that the trusteeship system is helpful is that, to the extent that there are concerns about slippery slope and this being so novel that it's disruptive to what we understand about international law, it provides some example of how this has been done, how we can imagine an extraterritorial governance. That, as an example, is simply to sort of allow for there to be a more comfortable understanding of how it would operate. But of course, again, very, 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 very key is that the trustees themselves would be members of the endangered nation. And I'm happy to find another term for that, absolutely.
Dr. Jacob?
Earlier today, it was mentioned that hope is an important element in motivating. I would provide a little scientific vignette that may create hope. Before the Industrial Revolution started, we were on the way to an ice age. So what I'm saying is that the states should think not about the termination of their nations. There will be a suspension for a few hundred years in which we could solve the technological and emission issues, and we could go back on our natural path to an ice age. This changes somewhat the role because it's not an end situation, it's a transitional state. And it could provide both hope, but maybe lawyers and politicians could find a way to make that clear to host nations. The sooner they stop the emissions, the sooner the hosted guest nations can get home.
Thank you. Yes, sir.
Thank you. First of all, let me congratulate the Columbia Law School and the Marshall Islands for convening this very important conference and addressing timely issues that we all have started to think about. It's been interesting listening to the two presenters about the legal implications. But coming from a small island nation, Maldives, which is far away from the Pacific and doesn't have the same group of islands together. For us, I would emphatically like to state, statelessness is not an option. It has never been and it never will be. We have survived for over 3,000 years, so we will continue to survive with or without UN membership. So UN membership is less important than our own survival. And while it's interesting and important to listen to the various options how we could continue, what I would like to say is that the sense of nationhood is not for the people, is not of UN membership, but there's what you call the connection with the land and the whole environment, the culture and the history. So even if we were given land somewhere else and were to move there, it does not give those people a nation. It does not take away what has been taken away from them. It does not give back to them what has been taken away from them. And no amount of resources or money is going to compensate for that loss of the identity of the people who has survived for many thousands of years. So I think in looking at the legal implications of sea level rise and climate change, what is much more important to be concentrating on is what are the responsibilities of the world, not just the developed world, but the whole world, the mankind as a whole, in ensuring that the weakest and the most vulnerable are not left to fend for themselves just because they are an inconvenience. Sure enough, these islands can disappear, and along with it, maybe a few millions of people, and the world will go on. Probably not much may be lost for many people, but is that what the civilization, after thousands of years, is that what human civilization has come to, where when countries or peoples become an inconvenience, that we let them go and let the Darwinian system of the survival of the fittest. Those who can afford will survive. Those who cannot, unfortunately, will either have to disappear or move elsewhere. And that, I don't think, is an option and should not be an option on the table for any country and should not even be, I don't think, even entertained. So I do not think it is right to contemplate statelessness for these people. I think it is very wrong, in fact, to think that these countries and these people should be made, should one day be stateless, because these are countries and peoples who are the least able to, if not totally, it's impossible for them to do anything to change the effects of what has the climate change. And they are the most vulnerable. And they cannot be, and they should not be, sacrificed on the altar of the good life of the rest of the world. And so I would think, in looking at the legal implications, I hope this conference will look much more, much less on the statelessness and much more so on the responsibilities and what legal responsibilities should be placed on the rest of the world community to ensure that these people, in fact, do not become stateless. Thank you.
Thank you very much. Minister Silk.
Thank you. Let me add to the thoughts that have been expressed earlier, specifically by Professor Josh. And let me, perhaps it is also a question that really it's in the right venue now to pose to all these lawyers here. And it has to do with, you know, we have a lot of conventions now under the United Nations. We have conventions to protect so many other things, including animals. So perhaps it's time that we consider an international convention or something similar to what we have in the Convention on Whales. This time, perhaps the convention should be, and it should be named something like this, International Endangered Human Species Convention. And perhaps that's something that the lawyers here could think about. And maybe that would be a way forward in accelerating the discussions and negotiations with the UNFCCC. Thank you.
And I would point out that the second panel this afternoon is on what are the legal remedies that could be available to the states and the peoples of those states. And we're having a session tomorrow on whether there is a need for a new international agreement. And as the minister says, we have an Endangered Species Act. We don't have an Endangered Peoples Act. We have reached the end of this session. We now break for lunch. We will resume at 1:30. Lunch is upstairs. You can, as I indicated, either take the elevator outside to 3 or take the steps that are near the entrance up one floor.